Everyone, and welcome back to NCSL's online redistricting seminar. I'm delighted to have so many people with us yesterday and today. And I'm hoping that you all had a restful evening, but something tells me that many of you may not have had a restful evening. Perhaps you were following the news out of DC, all I can say on that front is that it was hard to turn the news off. And for today, my hope is that I will be able to stay focused with us on what we're doing to prepare for the future. Also, by watching what was going on in DC yesterday, it became all the more clear how important it is that we're together for this seminar. We have the generous contributions of people from all walks of life, all political perspectives, all personal perspectives, who are serving as faculty for our seminar. And that's kind of a special thing that most people don't get, who only talk within their own bubbles. So I really appreciate that they are committed to sharing their expertise so that the capacity of the states to do a good quality job of redistricting is higher than it would be otherwise. It's really pretty impressive what the contributions we're looking at too. So I want to say something I said yesterday too, which was that I really appreciate the goodwill of everyone who has come with us now and who work with NCSL throughout the year. For me, working with people who do come from different walks of life is one of the most remarkable parts of my job. And I thank you all as faculty, and I thank you all as attendees. Now, we did kick off today with yoga and with negotiation. We didn't choose those two things thinking that things were going to be hot in DC. They just fit that category. I did the yoga. It was wonderful. This is chair yoga. You can do it in your office, and the recording of it will be available to you. So if you didn't get a chance, you have another opportunity. And the woman who does it, by the way, is the clerk of the New Hampshire Senate. So if she has time for yoga in her day, I am trying to commit that I will have time for yoga in my week, not necessarily my day. And then on the negotiating side, I didn't get to attend it, but I've seen Kurt Stedron, an NCSL person, do some of his work before, and he really makes a Zoom call sing. So do go back and watch that at some point. Tonight, of course, we have the trivia with our executive director, Tim Story. So I'm expecting most of us will show up for that. I mean, obviously it's not mandatory, but I think it's going to be fun. And so if you need a little distraction tonight, we've got it for you. Those are all my starting points. I want to turn it over to Michelle Davis. And as I do that, Michelle, I want to say thank you for being one of the 3 editors of NCSL's Redistricting Law 2020 book. It was such a treat to work with you for those several years, and I miss the fact that we don't have our weekly calls any further. And as far as I'm concerned, it makes you one of the 3 nation's experts on redistricting law. So with that, take it on.
Thank you, Wendy. And I have to say, I miss those calls too. And I still can't get the reminders to stop on my phone. Still don't know how to do that. But anyway, I want to welcome everyone here. I can't see everyone, but I can just imagine. And I think this is a very important topic. So I'll just get to it. I'm going to just give you sort of an introduction to the topic and then introduce you to our panel of experts. So to the topic of race and redistricting is so important because much of redistricting litigation centers on how race is used in drawing districts. Specifically, all states must comply with both the Voting Rights Act and the 14th Amendment of the Constitution. So let me quickly summarize what that means from a practical standpoint. In the case of the Voting Rights Act, the focus right now is on Section 2. And Section 2 requires or says that if a minority population is covered under that provision, the state must take remedial measures to protect that minority population's ability to elect its preferred candidate. In redistricting, remedial measures generally refer to drawing a majority-minority district. Now, the test for determining whether Section 2 applies to any specific minority population is commonly referred to as the Jingles test, named after the court case Thornburg v. Jingles. And Jingles requires 3 preconditions to exist in order for a group to be at least preliminarily covered under Section 2. The first prong of that test is that the minority group must be sufficiently large and geographically compact to constitute a majority in a single member district. The second prong is that that group must be politically cohesive. And the third prong is that white voters in that district or in the area under consideration must vote sufficiently as a bloc to defeat the minority's preferred candidate. And we commonly refer to that as either racially polarized voting or white bloc voting, to be specific. So if all of these factors are present, there is a preliminary legal presumption that Section 2 applies. The remaining part of the test continues to evaluate other contextual factors that reinforce Section 2 liability under what we call the totality of circumstances. And there's lots of case law on this that gets into the details that we can't get into here. A quick note on the other section of the Voting Rights Act that looms large, or that used to loom large, and that's Section 5. It is not operable at the moment. Shelby County v. Alabama, I think in 2019, if I'm not mistaken, June of 2019, I think I have that right, was decided so that section is not operable right now, and I'm sure you probably already know about that. So we won't spend a lot of time on that in this seminar, but we will talk about it because there's a small possibility. We can argue about how big or small it is, but there's a small possibility that Section 5 might come back at some point in the future. So moving along to the other law that affects race and redistricting, or I should say constitutional provision, and that is the Equal Protection Clause of the 14th Amendment. Which says race cannot be, well, I should say courts have interpreted this to mean in redistricting that race cannot be a predominant factor or tool used to make line drawing decisions. That is, the decision of where to place district boundaries cannot be made primarily on the basis of the race of the people included or excluded from the district. The only exception to this rule is if the state has a compelling interest in this race-based line drawing, and only to the extent that it advances that interest, in other words, narrowly tailored. So the tension between these two legal requirements in redistricting is obvious. If you ignore race completely by using sort of a colorblind approach to line drawing, that can easily lead to a violation of Section 2 of the Voting Rights Act. On the other hand, if you draw a line solely based on race, you could violate the Equal Protection Clause, and that would be considered racial gerrymandering, unless you fall within that exception. Now, of course, complying with the Voting Rights Act, especially Section 2, is certainly a compelling state interest. So problem solved, right? Unfortunately, no, because the state only really knows definitively if a district is covered under Section 2 only after a court sort of deems it so. So that's the catch. If a court disagrees with a state's assessment that a district is covered under Section 2, in many cases, this means you're left with a district drawn predominantly on race, and likely you have no other compelling interest to justify it. So I call this, I like to make up new terms, the compliance paradox. And since with Section 2 compliance, it seems only hindsight is 2020. So therein lies the problem. How do you draw districts in conformity with Section 2 if you can't be 100% sure if Section 2 applies? And it's true that in many of the cases that have resulted in racial gerrymander holdings for states and local governments, it came from sort of a misunderstanding of how to apply Section 2. So the questions become, one, how do states properly assess Section 2 applicability? And two, how do they avoid running awry of the 14th Amendment? So to get answers to this and other questions, I would like to introduce two practitioners who have a many years of experience in litigating this, and as well as being involved in sort of the academic part of this, which is a lot. Um, Let me start with, you may have heard of him, Jason Torchinsky. Jason, I meant to ask you how to pronounce one name in the law firm that you work for. So I'm so sorry. I'm going to really dismember this name, but he's a partner at Holtzman, Vogel, and
Giuseppe.
Josephiah.
Giuseppe.
Okay, it was close. It was close. And he specializes in campaign finance, election law, lobbying, and he spent a lot of time on redistricting cases as well. You can read his bio, I believe, in the official NCSL documents that come. And also with us is Dr. Christian Grouse, and he's a professor of political science and public policy at the University of Southern California. He also has a very extensive resume, but I don't want to spend the time to read that when you can look at it on your own, because I really would love to just get into some of the questions, because redistricting is coming. And I believe that these are some of these are very practical questions and issues that we need guidance on, states need guidance on. So let's just get to it. And my first question to the panel, and we can start with Jason to answer this question, it has to do with, real life line drawing. So given this tension we already have acknowledged between the Voting Rights Act and the 14th Amendment, what happens on the ground when race and party are strongly correlated, and the line drawing party, meaning usually the state, wants to take advantage of that? So at this point, you're able to take advantage of party, but not so much race. But when the two are very, very strongly correlated, how do you sort of toe that line? So in other words, could that violate the 14th Amendment? Where do you run awry of that? And what's the best way for a legislature to navigate between the 14th Amendment and the Voting Rights Act?
So that is a gigantic challenge for legislatures. And the reason that it's a gigantic challenge is, you kind of have hazards of liability no matter what you do. If you don't consider race enough and you fail to draw a district that the Voting Rights Act requires you to draw, you could face liability for doing that. The other extreme is you draw solely on the basis of race, you don't have the Voting Rights Act excuse, and now you've violated the 14th Amendment by intentionally racially gerrymandering. And then you've got this other sort of obstacle in the water that you're navigating, which is, a whole bunch of states have enacted new state laws that have some racial component to them that require you to consider or draw with this other pillar of state law. So you've got this water you're navigating. You've got, on one side, you've got the Voting Rights Act. On the other side, you've got the 14th Amendment, and somewhere in between, you may have these state law provisions. So it is a real tension. I think probably from the legislature's perspective, probably the best thing you can do is have data. You use actual data that you're relying on. Don't rely on anecdotal testimony from, African Americans or Hispanics or Asians or whites. Don't rely on the anecdotal testimony. Hire people like Christian, hire in-state experts, have people with PhDs or master's degrees, run the regression analysis, run the racial polarization analysis, do the compactness analysis of minority populations. And no matter what you do, base it on data. Because data that is objective is going to be the best way for you to defend whatever it is you've done as a legislature.
Christian, did you want to chime in on that?
Yeah, I agree. I mean, the data is really good. I would say the anecdotal part could be helpful in terms of creating narratives around it, but if you don't have data to back up those narratives through testimony, then you're gonna be in trouble. So I think the doing analysis, and I've done expert work on redistricting, right? Racially polarized voting analyses, is there a history in your state of minority groups losing the candidates of choice that minorities prefer losing regularly to candidates that are preferred by whites? It's relatively straightforward to collect that data, but I agree with Jason. If you've got the data, you're in better shape.
Okay.
One other thing I want to point out, and something that we saw in the 2020 election results, in a lot of states and even in certain regions within certain states, race and party may not be as strongly correlated going forward as it has been historically. You know, in the 2020 elections, you know, African American support for the Democratic Party remained historically high, but Hispanic support for the Democratic Party hit some lows. And so, you know, one thing you've got to be really careful about with Hispanic populations when your experts are doing their data analysis is, you know, one, I think it's a real mistake to try to treat any minority group, and in particular, based on evidence, treating Hispanic voters as a monolithic voting group, no matter where they are in the state, no matter what the historic country of origins are, or whatever, no matter what the history is of a particular region in the state. That's a mistake. You've got to make sure that your expert is attuned to those kinds of obviously you guys are state legislatures, the regional variations within your state that might exist. You know, I live in Virginia. You know, Hispanic voters in Northern Virginia may not behave the same as Hispanic voters in Southside Virginia. So it's just something that your experts need to keep in mind when they're trying to evaluate your state and the race party correlation or even racially polarized voting.
Okay,
Yeah,
thanks.
can I add to that a little bit? I mean, I would say that I don't think that the data so far, based on 2000, is showing significant moves of Latino voters away from the Democratic Party. I actually think that there's a bit of a blip in places like Texas, going back to the way things were in the 1990s in Texas. But I think if the analysis should not consider any one election, you need to look at, has a Latino candidate run for office preferred by Latino voters, and a non-Latino candidate run for office preferred by non-Latino voters, and are they regularly losing, right? And if so, then that would be the section 2, where there needs to be an attempt to draw a district that would have an ability to elect a Latino candidate. I mean, even if we just look at the results in Georgia on Tuesday, Latino voters in Georgia moved pretty strongly to the Democrats all over the state, based on the data there, because they do collect data by race and ethnicity. Even though that was a little less so in the November elections. But the question isn't about a move of, say, 10 or 20 points in one direction, which is what might be happening. It's actually, is one group winning and another group losing? And by group, I mean racial and ethnic group, not party.
Well, I think you can both agree that the analysis is the same. So what's going on in the aggregate in the country or even in the state means less than when you're actually looking at data from a particular district or area, right? So whatever is going on in that particular area is what you need to be concerned about, right? So let me move on to my next question. And Christian, I'd like you to answer this first. So how do you balance, especially if you're in a state that already has majority minority districts or minority influence or so-called ability to elect districts, how do you balance that, drawing those, maintaining those with traditional redistricting principles such as compactness and not splitting political boundaries, or quite specifically, what is the right number of majority minority districts under Section 2? And I know this is a great question because a lot of legislators just want to know that. They don't want to know about sort of the academic part and the legal theory. Just tell me how many can I draw or how many should I draw?
Yeah, no, that's exactly it. From a practical standpoint, I can get into the weeds and all that, but you want to just know, like, what do I need to do? What do I need to do when I'm drawing my lines? So I think the answer to that is really, you've got to do this racially polarized voting analysis. That's going to be the first step. And then the second step, you need to also, especially given the litigation that says you can't use race as a predominant factor, right? If you're using race alongside traditional redistricting principles like compactness, not splitting county and community boundaries, that more holistic view where you are drawing districts that may be majority minority or ability to elect minority candidates of choice alongside traditional plans, you're going to be in better shape in terms of litigation. Some of the more recent litigation suggests that race could be used when needed if there's a compelling interest, but also it should not be predominant, right? And so that doesn't give you a lot of guidance as legislators. Like, what does that mean, right? How many should I draw? What's the right threshold, right? A lot of litigation doesn't like the specific thresholds in the recent years. And if you go too far, like if you think going back to the 90s and even the 2000s, the courts ruled that was too much. And so what I would advise is to try to have more traditional redistricting principles alongside the protection of voting rights. And it is possible to draw voting rights districts in many places where there are cohesive minority groups that are not stretching across 200 miles. So in my home state of North Carolina, from Charlotte to Durham, right, in some of the most famous districts that were litigated in racial gerrymandering back in the 1990s. So that's the first thing, is think about this as a holistic procedure. I mean, one model I would look at is the California districts from the last decade. The California Redistricting Commission drew a number of voting rights Section 2 districts and used racially polarized voting analyses that were relatively compact and didn't split counties and cities. Sometimes it did, and sometimes you do have to split counties and cities. But it's the sort of the amount, and so that's one piece of guidance. And then what's the number? Like, what's the right number of districts that you want? That one I think is harder, right? But I mean, one good rule of thumb is that you don't want to be you may need a majority minority district to elect minority candidates of choice. But I think that's also something you can analyze, right? There's in some states, like multi-ethnic and multiracial populations, you might have a district that could be Latino and Asian majority. If the Latino and Asian candidates of choice are regularly losing and also voting for the same candidate otherwise, right? That's something that was done in California in the last decade to create coalition districts to meet some of the standards. And then in other contexts, echoing what Jason said earlier, if local level may suggest that Latino candidate of choice isn't going to win unless you have 60% Latino district. So I think you have to look at the history of voting and the patterns within each state and then each locality where you're planning on drawing the districts.
And let me just add something to what Christian just said, particularly when you're looking at Hispanic districts, the citizen voting age population number becomes significant to look at. So, Christian just mentioned you may need a district that's 60% Hispanic, but when you look at the citizenship percentage in that district, it may, 50% plus one is going to be your minimum under the VRA. But if you've got a state provision that requires or appears to require some sort of coalition district or even majority minority district, you may have to deal with that question. So I think one of the open questions that we still have on race and redistricting is whether the census is going to release more granular citizenship level data than we have right now, which may impact the analysis of the Hispanic districts or districts with Hispanic influence. My other caution about multiracial or coalition districts, if you're going to proceed down that route, make sure you have good evidence that those minority groups vote the same way. There were some cases, I think, last decade in Georgia where activists or the litigants were trying to argue that the African-American community and the Asian community in suburban Atlanta voted the same way. And I think those cases were rejected because ultimately the evidence showed that those communities did not vote cohesively. So if you're going to try for a coalition district, if you think that that's required, you should have evidence that the minority groups that you're trying to coalesce actually vote coherently.
Good point. Let's move on to litigation. So Jason, I'm going to start with you with this question, and it's kind of two questions. So in general, what courts are reviewing these cases? Are state or federal or both? And looking forward, how does the change in composition of the Supreme Court impact race and redistricting going forward?
Yeah, so those are both interesting questions. And Tuesday's election results made the first question even more interesting. Historically, most redistricting litigation has happened in federal court, in large part because in the 17 states that were covered by the Section 4 preclearance formula or Section 4 preclearance coverage formula, it almost never made sense to go to state court, because even if a state court did something, it would still require federal preclearance for that court's decision to go into effect. So most of the litigation, primarily in those states, went to federal court, and frankly, in a lot of other places, because the Voting Rights Act is the central question in a lot of these redistricting cases, a lot of this litigation happened in federal court. I think particularly with the growth of commissions and the absence of any current Section 5 preclearance formula or coverage formula, I think you're going to see more of a role for state courts. For example, the Virginia Commission that just got enacted provides that basically if there's a deadlock, the state Supreme Court is the fallback for drawing their congressional and state legislative lines. The Louisiana Constitution has a provision, at least for their state legislature, that provides that the Louisiana Supreme Court is the fallback if the governor and the legislature can't come to agreement. That's never been used in Louisiana, in large part because preclearance was there and everything had to go to federal court anyway. But now you're looking at a situation where unless there's a new preclearance formula, Section 5 doesn't cover Louisiana. So I think you're going to see a larger role for state courts in this next round. That may change if Tuesday's election, and we'll talk about this more, I think, a little bit later, if Tuesday's election does result in Democrats controlling the Senate, which it almost looks like certainly it will after these elections are certified, and Democrats do a heavy push for a new preclearance coverage formula, and they can hold every single one of the 50 Democrats in the Senate for the formula, and they get the vice president, and they can get agreement in the House, and they don't lose House moderates, you could see some sort of new Section 4 coverage formula reeling or putting a whole bunch of states either back under Section 5 preclearance or placing new states under a Section 5 review regime. If that happens in those states where Section 5 preclearance applies, you're going to see those state cases wind up in federal court. With respect to the changing composition of the Supreme Court, obviously everybody knows since 2010, the court now has 3 new members. However, I will say their specific views on redistricting are far from clear. And I think it's a mistake to assume that even the conservatives on the court are monolithic in their views in this area. And I'll just point to 2 decisions from last decade. The Bethune-Hill decision in 2017, there was a 6-justice majority in that case, including 2 justices who aren't on the court anymore. And the Cooper versus Harris decision, had a 5-justice majority. 1 justice in that majority has been replaced, and Justice Thomas was one of the 5 justices in the majority there. Kennedy, who had concurred in the judgment, isn't there now, and Gorsuch didn't participate when that case was decided. I think he might have been confirmed after the oral argument or something. I don't remember exactly why Gorsuch didn't participate in that one. So we really don't know, and neither Kavanaugh nor Comey Barrett participated in any Voting Rights Act redistricting cases when they were on the courts of appeals. And I don't believe Gorsuch did either when he was on the 10th Circuit. So in a lot of ways, we don't know whether the 3 new justices are going to be more in Justice Thomas's camp, more in Justice Roberts' camp, or frankly, more in Justice Alito's camp. And I don't think that there is a convergence of views, even among Thomas, Alito, and Roberts. I will tell you, for those of you who don't know, Justice Alito has more experience with redistricting than any justice on the Supreme Court since Justice O'Connor was there. Justice Alito's dad was the director of legislative services for the state of New Jersey, and is actually cited in a footnote in Karcher versus Daggett for an affidavit that he submitted when that case was going through the lower court. And Alito's talked about how a lot of his interest even in constitutional law grew as a kid, kind of watching his dad draw maps at the living room table. So if you go back and focus on Alito and his questions, particularly during the Rucho case, and actually for Michelle, the case out of Maryland on redistricting, Alito really understands better what state legislatures do than I think probably any justice sitting on the court. So those are interesting things to look at. The new composition of the court is going to do something, but I think it's unclear as to exactly what it's going to do.
Okay, great. Did you have anything to add, Christian? Uh-oh, I
I
think,
think we lost Christian.
yeah, I think so. Well, let's just keep going while he gets back here.
Oh, here he is.
Unless he, okay, he's back. Okay. Well, let me keep this moving. I have a question, and I wanted to direct it to you first, Christian. What kind of evidence is used to prove racial gerrymandering? And also, what data and metrics are needed to evaluate the presence of racially polarized voting, which is so important in establishing Section 2 liability? So, in other words, from the perspective of the people who have to draw the maps themselves, what sort of are the legal at the types of legal evidence that would prove racial gerrymandering, so that line drawers can avoid it, and what do they need to sort of assure themselves that they're covered, or a particular area district is covered under Section 2, which a lot of what centers around determining the presence of racially polarized voting.
Yeah, thanks. And sorry, my internet dropped off there, but it's a great question. I mean, the first thing is on the Section 2 side, as we were talking about a bit earlier, you want to collect data on precinct level election returns that involve candidates that may be candidates of choice, which I'll get to a little bit more in a second. So precinct level data, racial and ethnic population at the precinct level, and that's where the census data are going to be really important. Having CVAP data can be important too, as Jason was discussing when you're looking at the districts. And then you take a look, and typically what's been done is you take a candidate, often who is of the same racial or ethnic group of the minority group, who runs against a candidate who's not of the same racial or ethnic group. And then you see, does the majority of one racial or ethnic group vote differently than the majority of the other racial or ethnic group? And so simply, are they regularly not voting for the same candidates, right? And so that would establish that there's cohesive groups, and then the minority group is regularly losing, right? So their preferred candidates.
So just to clarify, and the reason why I'm doing this is because there's actually an audience question about this. So for if you have voter registration data, but you don't have any race or ethnicity data associated with the voting registration data, and I don't think anybody really does. So what you're saying is you sort of have to take the voter registration data and marry it to the census data for the same geography, and draw the picture there, and also the election data. So in other words, you need 2 or 3 data sets together, right?
Yeah,
Right.
Michelle, though, let me add, if you look at states that were covered under the old Section 5 preclearance formula, the majority of those states actually ask the race and ethnicity question on their voter registration records. If you were not in a Section 5 covered state, the race and ethnicity data is probably not in the voter registration record. So, I know Maryland wasn't covered, so you wouldn't have seen that. But like in Georgia, as Christian just mentioned, the race and ethnicity data is in the voter registration record in Georgia.
Yeah,
So
I think there are 8 states, mostly in the South, that do collect race and ethnicity of the voter registration. Yeah, I might have the numbers off slightly.
Okay.
But
Go ahead, Christian. I'm sorry to
yeah, no,
interrupt you.
that's great, Jason. That's one of the things I was about to say. So in most states, you've got to pair precinct level racial and ethnic data with election data. But in these states that have collected individual level data at the voter registration level, you can just use the individual level voter registration level. And then you just so that's step one, is you just need to look at those data and then determine, is there racially polarized voting and candidates of choice of the minority group losing. And then the second step would be, well, what other data do you need? How do you determine if race is a predominant factor, right? And so some of that becomes data and some of that becomes legal. right? You want to make sure you're drawing a district that has the ability to elect a candidate of choice of the minority group, right? And so, this varies depending on the local context, but in the past, that would have been a majority minority district. In some contexts, that may be, and by minority majority district, that might have been a majority black district, a 50.1% black district, perhaps higher with other groups. But contextually, if there is evidence of a cohesive minority group voting cohesively with another minority group and losing regularly against white candidates of choice, you could have a district that maybe is a 45% minority group paired with a coalition of 10%. And so I think that's something that, especially as the many states are becoming much more multiracial and multi-ethnic, that's going to be some of the frontier on that. I will say, as a PhD and not a lawyer, the legal part of that I think is going to be developed over time. But because and it has been some. But on the other hand, kind of echoing what Jason was saying, Supreme Court seems to be wanting to punt on redistricting, at least in terms of partisan gerrymandering, and so they might be kind of tired of the racial gerrymandering stuff too. So it's hard to say what might happen, and then it really is about the state courts and the state requirements. And then I'll just add to that, I do know some states, and you want to make sure, in addition, for like what data do you need, some states actually require much more than is in Section 2 of the Voting Rights Act, and so you want to think about that. And then there's also no prohibition from drawing districts that do not use race as a predominant factor that could potentially elect minority candidates of choice. So that's something that can be done and may need to be done, even if it's not required by law. But you cannot use race as a predominant factor.
So that would be, for lack of a better term, sort of a naturally occurring minority district. You don't have to do much to make it a district. It's just a blob, a circle, a square, and it doesn't cross any county lines or anything like that. Is that sort of what you mean?
No, I was thinking more. There's no. We're very focused on minority majority, right? There may be districts where it is not possible to draw a minority majority district, but that the legislature may think it's it may be in the interest of the group to have a coalition district where they're in the minority, okay. Right? That's what I mean. And so and within geographic compact and other traditional redistricting principles too. So race is not the predominant factor.
Let me add just a couple things to what Christian was saying. When you're collecting the election data, make sure you're looking at both general elections and primary data. Don't look only at general elections, because a lot of the racial questions will come into play in Democratic primaries. In particular, again, because as we've talked about, a lot of minority voters tend to participate in Democratic primaries. So if white Democrats can constantly beat minority Democrats in primaries, and then white Democrats go on to consistently win the election, you're not just looking at general election candidates. The other thing I'll point out is, just to give you an example of some of the other sources of race, I'll give you the language from the Colorado provision, the newly enacted Colorado provision. It says, denying or abridging the right of any citizen to vote on account of that person's race or membership in the language minority group, including diluting the impact of that racial or minority language group's electoral influence. That's a prohibition in Colorado. In Virginia, it says districts shall provide, where practicable, opportunities for racial and ethnic communities to elect candidates of their choice. So 2 states, new language, none of which is entirely on point with Section 2 of the Voting Rights Act. So Virginia and Colorado are probably going to have some interesting questions about what that means. Is that the same as Section 2? If it is, then why didn't they just say follow Section 2? If it isn't, where is it different? What does it require? Does this language require something that violates the 14th Amendment? These are legal questions that haven't been tested because these are newly enacted provisions. But I do expect that all of these legal questions in these states that have adopted language like Virginia and Colorado will be tested.
Thanks, Jason. So I want to look ahead here at the possibilities, and I know there's probably disagreement on how likely this this might happen, especially this year. But given the fact that it appears that we're going to have a Democratic controlled Senate or close to it, um, my question is now there's more of a possibility, I'll just say more of a possibility, that Section 5 of the Voting Rights will be revived, so to speak, by Congress approving a new coverage formula in Section 4. So I do remember that after the Shelby decision, it was a bit of a shock when that happened, and immediately there were drafts of legislation about that suggested new coverage formulas. And now that we've had the elections in Georgia, and there's more of a possibility that we'll have a new coverage formula. Now the question becomes, well, what will that look like? We know that we can't just do the old formula. The old formula wasn't really much of a formula, right? So what do you know about what the possibilities are? And my concern is, are there going to be states on it that you might think maybe shouldn't be on that list, depending on what proposed legislation we're talking about? But I've heard about different proposals that place different states on the list, and there's a lot of controversy about whether what's a good list, what's the best formula. So what say you about that? So let's just start with Jason, and you tell me what you think.
Sure. I don't know what the formula is going to look like that is going to get proposed in the House. I don't know what formula will be able to pass the House with the narrowed House majority. I don't know what could get past the Senate. I don't know what it would take to have, to hold every Democrat if all Republicans held. I don't know what kind of coverage formula might appeal to a Republican or two, or 5 or 6 or 10 or 12 or 20 who might vote with Democrats on a coverage formula in the Senate. I do know that something that covers too broadly is going to probably not pass either the House or the Senate. I think if they're going to pass something, it's got to be something much more targeted and focused. I think that a coverage formula that relies on mere allegations of voting rights or racial issues are probably not going to fly with most Republicans, and probably is not going to fly even with some moderate Democrats. So I don't know what the formula is going to look like. My other big question for a new coverage formula and redistricting in 2020 is, could they pass a new coverage formula fast enough with an effective date soon enough to cover redistricting for the 2022 elections? If they follow a traditional legislative process, right, hearings in the House or Senate, or hearings in the House and Senate, and then a conference, and then time on the floor, and then presumably there'll be some sort of power sharing agreement in the Senate if they have to go through the committee discharge process to get it out in the Senate. I'm not sure that this necessarily comes into effect in one of the first bills. So I don't know when they would pass it. I don't know what the effective date would be. I don't know how long it would take DOJ to implement new regulations and pre-clearance procedures. And I don't know when the census data is going to come out. So when you combine all this uncertainty, I do think there's going to be a push for a new formula. I don't know what the formula is going to look like. I don't know what the effective date's going to be. And I don't know how any of that is actually going to play or tie in with the timing of the release of the census data and line drawing for 2022. Because keep in mind, right, like for states that have their early primaries in 2022, like for example, Texas, which as Christian mentioned, always seems to have a lot of Voting Rights Act issues. The Texas primaries are in February of 2022, and their qualifying is like either late November or early December. So if census data doesn't come out till June or July, and a new coverage formula is not released and debated and passed and adopted until August, it's hard for me to see how all of that could come together to be into effect to cover every state for 2022. So it's a lot of uncertainty that we all have to watch for.
Christian, anything to add?
Yeah, so I think there's a little bit more of a chance maybe than Jason. I do agree with the timeline. And so if I'm a state legislator or a line drawer, what am I thinking about? Right now, just you need to proceed as planned, but be prepared in case something does get passed very quickly at the beginning of the next Congress. I do think there's some some interest definitely on the Democratic side, and it wouldn't even surprise me if there's some moderate Republicans who might come along as well. If in 1982, it ended up being passed in a pretty bipartisan way after a lot of back and forth between the Republicans and the Democrats. It did actually pass in 82 and didn't get implemented until 92 for redistricting, that so what Jason was talking about. In terms of the coverage formula, right now there's HR 4 introduced in the previous Congress by Terry Sewell in Alabama that has some of those details, and I don't know if that's what the coverage will look like in any proposal that might be coming out in the next couple of weeks or months.
Okay, thank you. I'd like to, since it's 11:46, I'd like to move to some of the audience questions, and we've been getting some. So I'm just going to read them. I've been trying to read them while you guys are answering. So let me start with this one. Let's see here. Is there, this seems to be, should be a quick answer, maybe. Is there an accepted methodology, perhaps from academics, on conducting a voting polarization analysis? How many election cycles do you need, for example?
Yes, that's a great question. So there is an accepted methodology, both academically and also legally, right? And so this is the racially polarized voting that I've been talking about and that Jason was talking about. Basically it's regression. I will try to avoid the details, but if anyone wants to follow up with me about how it's exactly done, I'm welcome to share that later. Email me. But it takes that precinct in the states that don't have individual level racial data for voters. It takes the precinct level data, the election results, and then you regress them, and then you have a follow-up analysis where you analyze if the candidates are candidates of choice, and then what the likely percentage needed of the minority group to elect a candidate of choice of the minority group, right? So step one, is there racially polarized voting? Step two, does the candidate of choice of the minority group lose regularly? Step three, what's the percentage that would be needed in a district to draw a Voting Rights Act Section 2 district to elect a candidate of choice? And so how many elections do you need? Ideally, you need as many as you can get. It's often a question of how much data is available, not a specific number. And usually in the litigation over districts after the lines are redrawn, the experts will typically use different elections, unfortunately, which is where some of the questions come in. But the more data you can get, the better. The more election data you can get, the better. And I would go back in time, at least say the last, there's no rule of thumb here, but at least the last 6-8 cycles if you have access to those data.
The one other thing I'll say on the data is the best elections are what they call the endogenous elections. In other words, elections for the office that you're looking at, right? Because how people vote for president may be different than how people vote for mayor. So you really want to try to find elections that are the best elections are the ones that are most recent and closest to the level of election that you're looking at. And the sort of the older the election or the further away in kind of level of election that you're looking at is, the sort of less persuasive it is to a court. So you really want to try to find close in time, close in level as your best evidence. But that's not always possible, right? You can't always necessarily find a clear candidate of choice if there have only been white candidates for state legislature in District 41 for the last 20 years. So there may be times where you have to look outside that particular level of election.
Okay, thank you. I have another question, and this is I think I want to ask you this because I think a lot of times people conflate these two things when it comes to the Voting Rights Act. So please comment on the potential relationship, intended or unintended, between the creation of majority-minority districts and packing. Either one, if either one of you'd like to take that.
I mean, I'll start. I think that the Christian majority minority districts is not necessarily packing, right? So if we go back to the 1990s cycle, right after the initial section, 1982 Voting Rights Act was passed, a lot of states packed in black voters, especially across the South, North Carolina, Georgia, Texas, into districts probably at higher numbers than were needed. And then that's what spurred a lot of the Supreme Court litigation saying race is the predominant factor is a real problem. You can't use race only, there needs to be more. And so if you're packing black voters or Latino voters too heavily into a legislative district, you are going to potentially be running afoul of the existing litigation. And it also creates there's other issues too at the state level, depending on your state. And then, but do you then go all the way down to sort of really low numbers of minority voters, especially if white voters are regularly voting differently than minority voters? That's also a problem. So you really got to get that. This going back to Michelle's point of what you called the paradox, I think, the compliance paradox.
Paradox.
Yeah, which I love, by the way. Like the packing is a real problem legally and also representationally, but then you go too low and you'll end up with a bunch of legislative districts that only elect white candidates of choice.
And again, this is all in the context of whether or not you're covered under Section 2. So if you're covered under Section 2 and you feel like you need to draw a district, it does have to be a majority-minority district, or otherwise it wouldn't be covered under Section 2, right?
Well, right, but everyone's covered under Section 2.
Yeah, I was just going to say exactly that.
But what I'm saying is it has to be, it can't be a district where your minority is below 50%.
Well, right, that's the current jurisprudence from the Supreme Court with respect to the Voting Rights Act. However, if you're in Virginia and the state constitution says districts shall provide where practicable opportunities for racial and ethnic communities to elect a candidate of their choice, could that result in saying, hey, I need to draw a district that's 42% Hispanic in this part of the state? I don't know what that language is ultimately going to be interpreted to mean. And if you are required to do by a state statute to have some minority percentage somewhere that is below 50%, is that going to violate the federal constitution? Because now you're intentionally using race to draw a coalition district that isn't a compelling interest required by Section 2 of the Voting Rights Act. So I'm not sure that a number of these state-based sort of racial requirements are going to survive 14th Amendment scrutiny.
Interesting. So what you're saying is a state law may not be a good enough compelling interest.
Right. Or in other words, can the state mandate something that is a compelling interest enough to get around I can't use race intentionally under the US Constitution? And I'm not, the courts really haven't dealt with that. But I think given some of the new language in some of the places around the country, I think courts are going to have to deal with that.
I think in the Rucho decision, which was not on racial gerrymandering, but on partisan gerrymandering, the court definitely signaled that states could make laws in ways they saw fit. So if they move that over on the racial gerrymandering side, you might have a lot more leeway for states to do what they want in terms of making laws about race and requiring race to be part of the redistricting process.
Okay, thank you. Here's a question. Is there guidance on protections for separate minorities that tend to favor different candidates in primaries, in particular, large Black and Hispanic areas within cities?
I mean, this is one where you've got to look at, if you have a city that has a large black, or any area that has a large Black and Hispanic population, one of the first questions you have to look at is, one, is the Hispanic community cohesive among the Hispanic community? And then do Hispanic communities and Black communities in that geographic region tend to support the same candidates, particularly in Democratic primaries? And sometimes the answer will be yes, and sometimes the answer will be no. But the data is going to drive you to where that answer is.
Okay, and I think this is a similar question, and I think this all goes to how complex sort of evaluating where you stand under Section 2 when you're trying to draw boundaries. It says, if there's a sizable and concentrated Hispanic population in an area, but no clear record of Hispanic candidates of choice trying and failing to get elected, is the Voting Rights Act district needed?
This is where you have to look at, I think, and Christian can sort of weigh in too, but I think if there aren't minority candidates, but there is substantial minority population, you have to look at the votes. In other words, you don't have to be a Hispanic, you don't have to be of Hispanic origin to be the preferred candidate of Hispanics. You don't have to be African American or Black to be the preferred candidate of an African American community. You've got to look at how those votes are. If you had a race between two white people in an area that was substantially Hispanic, and regression analysis showed you that 90% of Hispanics voted for Jane and 90% of whites voted for John, you still have polarized voting and a clear candidate of choice, even though you didn't have a Hispanic candidate. So if you have the absence of minority candidates, you need to look and see whether there is a clear preferred candidate of choice among the non-minority candidates.
And if there isn't a clear candidate of choice, which I'm sure has happened, then Section 2 doesn't apply. Am I right?
Right. If you don't have racially polarized voting, you don't meet one of the clear prongs of the Jingles test.
Yeah, I will add, if you think there's not a candidate of choice, I would look for other elections. If the group is large enough in a state to be potentially in a cohesive group, there are probably minority candidates of choice running for something somewhere, and if not, will be soon. I know in California there are advocacy organizations that encourage candidates to run, right? And so that's the kind of thing you could maybe reach out to various organizations in your state and find out, who are people you might not be thinking about who are maybe at lower levels of elections where you collect data on candidates of choice there.
I mean, just look at the Democratic presidential primaries in 2020. You had candidates of almost every racial and ethnic origin running in almost every state. So you've got, kind of the pick of all kinds of various races, just if you want to look at Democratic presidential primaries. You've got to be careful there, because when did candidates drop out and things like that. But, there's just an example of the kind of panoply of candidates that are available to look at and analyze when you're looking anywhere, even if there haven't been, candidates for city council who are of the same minority group.
Okay. Another question about unaffiliated voters. I actually have that question too. How do you treat unaffiliated voters when you're doing racially polarized voting analysis? Do you not consider them, or how do you treat them?
Generally, when you're doing racially polarized voting analysis, you don't look at party affiliation if you happen to be in a state that records party affiliation. So I'm not sure that party affiliation matters when you're looking at racial questions.
I think I agree. The one thing is, if you're talking about looking at primary elections, right? So if you're in a state like Florida that has a close primary, I think close to 40% of Latino and Asian American voters in Florida are registered with no party affiliation. And so you want to at least make sure you're analyzing some general election data if you're looking at Asian American and Latino voters in a state like Florida, compared to states that have open primaries, where the primary elections and the and the general elections could matter too. And especially in Florida, African American voters might actually have some racial polarization in a Democratic primary and a closed primary that would be meaningful and important. And then Latino voters, you may actually want to be looking at general elections as well as primaries because of the high levels of unaffiliateds among Latinos in Florida.
Okay, here's an interesting question. Can you comment on how to handle Indian reservations? Should you ever split them up?
I mean, the first thing that's going to drive the question of whether you should split up Indian reservations is going to be the equal population rules. You know, if a reservation's population exceeds the ideal of a single district, you have to split the reservation. So the first thing that's going to drive that question is going to be the equal population rules, and then you've got to look at, you know, all of the other same race factors that we're talking about here. There aren't special Voting Rights Act rules for reservations, just as a pure legal matter.
Okay,
Yeah,
and
and there were two counties in South Dakota that were covered under the previous Section 5 formula, in part due to how things had been handled. So I think that, you know, splitting a reservation down the middle could be potentially problematic, but you have to look at all the rest of the data.
yes, okay, and I have a question myself, but I think a lot of people will be wondering this, and I think I've sort of asked this for my state, but I want to ask for all states in general. If you are in a state that has not had any significant voting rights activity, in other words, Section 2, or a history of coverage under Section 5, but over the last 10 years, there have been some demographic changes, and you're not sure now when you sit down to redraw the map if those demographic changes have, you know, sort of come to the point where you might need to start doing some kind of Section 2 analysis. In other words, what sort of is the marker, or if there is a marker, or any tell in your statistics, especially in your urban areas. I think New York City is an example. I think Jeff Weiss has talked about this, that over the last 10 years, there have been some significant demographic changes. So my question is, if you've never had to deal with Section 2 before, it doesn't mean that you won't have to deal with it in the future. So my question is, what is sort of the evidence that you need to see or look for to give you a hint that, hey, maybe you should be thinking about this, or you need to start doing the analysis?
If you've not had Section 2, you know, if you've not had districts that you know were Section 2 in your state before, or don't have a history of Section 2 litigation, I would look for, you know, anywhere in your state where you have substantial increases in minority population from where minority population was last census. Because if you don't have the substantial minority population, again, assuming no state level racial requirements, if you don't have the substantial minority population, you're not going to have a Voting Rights Act requirement. So you know, one of the things you can do, it's relatively easy in the mapping software to say, okay, show me Hispanics from 2010 to 2020, and you can see where the differences are if you have substantial expansion in Black population, Hispanic population, Asian population, whatever minority group you're looking at. You know, growth in minority areas and growth in minority population is going to be your first kind of tell that you need to do some additional looking.
Would you like to add anything, Christian?
I agree. Look at the growth in your state, especially. I would especially think about Latino growth in a number of states that maybe previously would not have had as large a Latino population.
And I would assume that whatever the extent of that growth is, whether it's single digit, double digit, it would depend. You would have to compare that to sort of the size of your own districts.
Yeah. And
right.
In particular, I agree. And in particular, if you're looking at his increase in Hispanic population, you really also need to look at the best citizenship data that you have available. if you have a substantial number of new immigrants who are not citizens in a particular part of your state, the Voting Rights Act is probably not going to cover them. But if there is a decent citizenship percentage among, that population, you're definitely going to need to consider the Voting Rights Act.
Excellent. Well, I'm told that we are at time now, so that's it. I think we did answer a lot of the audience questions, though. So that was really great, guys. Thank you so much.
All right. Thank you.
Yeah, thanks.
All right. Bye-bye.